So another Second Amendment case is up for Ninth Circuit review, but this case is the result of Saint Benitez siding with the state of California. So let's talk about this. But real quick before we jump to this video, if you think the state of California needs to stop infringing on our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, which is Safe Life Defense. Safe Life Defense has some of my favorite soft body armor out on the market. I actually keep one of their soft body armors in my vehicle just in case. And right now they are running a Black Friday sale, so go ahead and check them out. I'll put a link to them down in the details section. And if you use the code ARMSCHOLAR, you can get an additional 10% off of your order. Also want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, the case we will be talking about in this video is Fouts v. Bonta, which involves a Second Amendment challenge to the state of California's ban on the ownership of batons and billy clubs. This is a case that went before Judge Roger T. Benitez / Saint Benitez in the Southern District of California. But in reviewing this case, he found that California's ban was not a violation of two-way rights, which is really concerning. The California law being challenged in this case is California Penal Code Section 22210. It prohibits the ownership of billy clubs, which are also known as batons. California Penal Code Section 16590, subsection M, designates a billy club as a generally prohibited weapon. A billy club is also designated as a nuisance, subject to confiscation and summary destruction if you are found in possession of it by law enforcement. These laws amount to an unconstitutional infringement because the state is restricting the type of arm someone can possess and use for their own self-defense, even within their home. Therefore, plaintiffs challenge the law in California as a violation of their Second Amendment rights. Plaintiffs in this case who are challenging this California law are both military veterans, and they both have received training on the use of collapsible batons, which they wish to possess. The plaintiffs argue they both wish to purchase collapsible batons as well as other batons typically issued to individuals like police officers. They wish to own them for self-defense and other lawful purposes in their homes, and they would like to acquire, possess, and potentially carry them where appropriate just simply for their own self-defense. The plaintiffs brought a challenge in the Southern District of California before Roger T. Benitez. However, Benitez granted a motion for summary judgment in favor of the state of California and dismissed this case. So that's right, Saint Benitez himself, the judge who found California's ban on so-called assault weapons and so-called large capacity magazines, that individual, that judge who found that those laws were unconstitutional, in this case, he ruled in favor of the state of California and dismissed the case. He upheld California's ban on the possession of batons by holding that, under controlling precedent precluding further analysis, because the 104-year-old regulation is long-standing, it is therefore beyond the sweep of the Second Amendment. Now, I tend to give credit where due and criticism where due, and in this situation, I believe Judge Roger T. Benitez, or Saint Benitez, just simply got this case wrong. Well, the plaintiffs decided to appeal that decision by Roger T. Benitez, and it is now up for Ninth Circuit review. In their appeal, they made two main arguments. They first argued that California's ban on batons violated the Second Amendment because the ban is not long-standing and because batons are not dangerous or unusual. And they also argued that the court should apply strict scrutiny on the ban, but even under intermediate scrutiny, the ban would still fail. So let's look at some of the arguments that were made in their brief up to the Ninth Circuit. In the first section, in arguing that the ban violated the Second Amendment, the plaintiffs argued that Judge Roger T. Benitez improperly found that the 1917 law is longstanding and therefore constitutional. They argued that, as even stated in the en banc panel in Young, courts should look to see what restrictions were permissible in 1791 when the Second Amendment was actually ratified to determine what laws are longstanding. This type of argument is also consistent with oral arguments that we recently had heard before the Supreme Court in the New York State Rifle and Pistol Association case, where many of the justices actually argued that you start with the text of the Second Amendment and then you turn to history and tradition surrounding the time of the text's ratification. The plaintiffs argued that a law from 1917 is not part of a longstanding tradition because there is no evidence that the law is reflective of a tradition that goes back to the time of the founding or the time of the ratification of the Second Amendment. They go on to state that it is not longstanding because there was not a history of prohibiting the possession of batons during the founding era. The trial court acknowledged that colonial bans on batons did not exist. This is for the simple reason that it believes the weapon known as a billy apparently did not exist at the time of the founding of our nation. However, clubs and other weapon-shaped sticks are covered by the billy law and were in existence at the time of the founding. Now, I think this is a strong argument that the plaintiffs are making. Judge Benitez argued that billy clubs and batons did not exist at the time of the founding era. That may be correct, as there were no items actually named billy clubs or batons, but simply bludgeoning items, sticks, clubs, etc. have existed and have been used since the beginning of human history. Therefore, to argue that batons are not protected under the Second Amendment because items like them did not exist at the time of the founding is simply not historically consistent. In the next section, plaintiffs argue that batons are not dangerous and unusual. The argument they make in this section really is very straightforward. They argue that because batons are less dangerous than handguns, which the Heller court found to be the quintessential self-defense weapon, they are not dangerous and unusual. Batons cannot be legally dangerous and lose Second Amendment protection, since other items like handguns, which are both concealable and way more lethal than any type of baton that has ever existed, those actually have been found by courts to not be dangerous and unusual. Really, it should be hard for the state to make the argument that batons are more dangerous or unusual than actual firearms, but that's exactly what they're trying to do with the type of law that they have here in this outright ban on batons and billy clubs. The next section of the brief, the plaintiffs move to discussing the type of analysis the Ninth Circuit should engage in when reviewing this issue. The Ninth Circuit currently deploys a two-step approach where they first ask if the challenged law affects conduct that is protected by the Second Amendment. If it does, then the court moves to step 2 to determine what level of scrutiny should apply. In this section, plaintiffs argue that the law here is more analogous to a categorical ban, like what was found unconstitutional by the Supreme Court in Heller. The plaintiffs state a ban on all clubs that can be used as a baton constitutes a class-wide ban on arms for self-defense, just like the handgun ban in Heller. They go on to state that several courts have followed Heller's guidance and struck down electric gun bans without the need to apply levels of scrutiny. And then they state that this court should follow circuit precedent under Heller and the aforementioned state courts and apply a categorical approach to strike down California's ban on batons. However, it's unlikely the Ninth Circuit will apply categorical rules and categorical analysis, so they say that if the court decides that that doesn't apply, they should apply strict scrutiny. Now, strict scrutiny is a type of analysis that is higher than intermediate scrutiny. A lot of time, the governments and states try to argue for intermediate scrutiny because it's easier for their type of ban or restriction on Second Amendment rights to pass that level of scrutiny. So here, the petitioners, the plaintiffs are arguing that if the court finds that the categorical approach does not apply, they should apply strict scrutiny, not intermediate scrutiny. They argue that strict scrutiny should be used over intermediate scrutiny because California's ban also affects a person's right to have a baton in their home for self-defense, which is at the core of the Second Amendment and therefore imposes a substantial burden on their Second Amendment rights for self-defense because, again, this is an outright ban on the possession of batons even within your home, so that strikes at the core of the Second Amendment. The plaintiffs then close out their brief by arguing that even under intermediate scrutiny, if the court finds that strict scrutiny shouldn't apply and they apply intermediate scrutiny, even under intermediate scrutiny, an outright ban would fail. So this case is really different because it involves a type of arm that really doesn't get talked about a lot. But under the Second Amendment, you have the right to keep and bear arms. And that right to keep and bear arms would include batons and your right to keep and to bear them for your own self-protection if you find that that's the type of arm that you want for self-defense. But one thing I wanted to also note is that the Supreme Court's decision in the New York State Rifle and Pistol Association case could even impact a case like this because the Ninth Circuit's two-step approach is not the standard that was outlined in Heller. If SCOTUS reaffirms text as informed by history and tradition as the appropriate type of analysis and the whole analysis in the New York State Rifle and Pistol Association case, that would trickle down to other cases, even this one involving batons, because again, it's still a Second Amendment question. So when the Supreme Court hopefully reaffirms the appropriate type of analysis in New York State Rifle and Pistol Association, it would trickle down to the Ninth Circuit, who likes to use the two-step approach, which isn't the correct type of analysis. So hopefully that gave you some insight on an interesting case that's made its way up to the Ninth Circuit that also involves your Second Amendment rights. Now, if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel algorithm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of 2A news. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You guys are directly impacting these videos. You're directly impacting this channel, helping me to reach more people than I could have ever thought was possible. You guys helped me reach my goal of 200,000 subscribers by the end of the year. Now we are rapidly trying to reach that 300,000 subscriber goal, but I never would have thought that was possible. And that's all because of you guys. So thank you so much. If you don't have a comment in mind, just comment down below that you're commenting to fuel the algorithm. And also, if you're a new subscriber, go ahead and comment down below that you're a new subscriber, and I'll make sure I comment back to you. So as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this is Built by Arm Scholars and Sustainably Maintained by Arm Scholars.